Welcome to the short video on safeguarding children. This is the first in the series. In this session, we are going to learn about the law with regards to sexual offences against children, which applies in England. I'm Dr. Krisha Patel, and I'm a sexual offences examiner for Mountain Healthcare. I support the police and safeguarding team to gather any medico-legal evidence in cases of child sexual abuse. This training is interactive, so the first question is over to you. What is the key legislation covering sexual offences in England and Wales? So the key legislation, of course, is the Sexual Offences Act 2003. It applies to England and Wales only. Northern Ireland and Scotland have different sexual offences legislation. It's broadly similar, but there are some slight differences. These are just some of the offences against children listed in the Sexual Offences Act 2003. Some of them involve direct contact, and some of them we refer to as non-contact offences. Sexual activity with a child, so that's a contact offence. Causing or inciting a child to engage in sexual activity, so that could involve an adult causing a child to perform a sexual act on another person. That other person could be another adult or another child. Or inciting the child to behave in a sexual way or to masturbate, and that can be in real life or it can be online. Engaging in sexual activity in the presence of a child, causing a child to watch a sexual act, so these are non-contact offences, arranging or facilitating commission of a child sexual offence, meeting a child following sexual grooming, and sexual communication with a child. There are many other offences that are listed in the Sexual Offences Act. So here's the second question. At what age does a child become an adult? So the definition of a child is someone up until the age of 18, and that's defined in the Children Act 1989 and also in the United Nations Convention on the Rights of a Child. This is the age they have the right to do everything an adult can do. They can marry, vote, gamble, take out credit cards and mortgages, buy alcohol and cigarettes. As the child matures, they are allowed progressively more rights as set out in legislation. At the age of 10 in England and Wales, they have reached the age of criminal responsibility. What that means is they can be prosecuted for a crime and punished with a prison sentence. Cases of children being prosecuted at such a young age are thankfully rare. The most high profile, of course, would be the prosecution of John Venables and Robert Thompson, who were themselves aged only 10 at the time when they tortured 2-year-old Jamie Bulger in a tragic murder from the 1990s. Once the child reaches 16, under the Mental Capacity Act 2005, they are presumed to have capacity to make decisions about their own medical care. However, the child becomes an adult at the age of 18, which is when they are essentially allowed to do everything. Next question, what is the age of consent for sexual activity for people of the same sex, so both male, for people of the same sex, both female, and for people of the opposite sex, so a male and a female? All of the answers are 16, as set out in the Sexual Offences Act. What about teenagers between 13 and 15? Sexual activity with a child under the age of 16 is a criminal offence. The law is designed to protect children who are recognised as being a vulnerable group. So although sexual activity with a child under the age of 16 is a criminal offence, this is a bit more of a grey area, as the Home Office has made it very clear that the law does not intend to prosecute teenagers who are engaging in sexual activity. Is it in the public interest to prosecute 2 teenagers between the ages of 13 and 15 who are engaging in consensual sexual activity? Would it be in the public interest to prosecute this? This is one of the 2 tests that have to be met for the police or the Crown Prosecution Service, which is usually shortened to CPS, to decide whether it's worth prosecuting a crime. Sexual offences against children under 12, for example, or murder are crimes that would be in the public interest to prosecute. The other test is called the evidential test. which basically asks, is there enough evidence which is reliable and credible to give a realistic prospect of conviction, which is usually meant as meaning over 50% chance of conviction. But if we're talking about two teenagers between the ages of 13 and 15 who have engaged in sexual activity, and both parties are truly consenting, both are of similar age in terms of development and maturity, as well as actual age, and as long as there's no element of coercion, exploitation, power imbalance, use of drugs and alcohol to facilitate sexual activity, then it would not be in the public interest to prosecute that crime. As if the activity was truly consensual, then both children would bear responsibility. And as mentioned, the Home Office has made it very clear they do not intend to pursue cases like this. Special protections for children 12 and under. The law says the child of 12 and under is unable to give consent to engage in any sexual activity at all, and this is completely black and white. There's absolutely no grey area in this. Crimes against children 12 and under are considered more serious, and this is reflected in the maximum prison terms and the higher penalty as defined in the Sexual Offences Act, compared to crimes against children over the age of 13 or over the age of 16. So the next question over to you is the law the same with regards to those in a position of trust? So by this, I'm talking about doctors, teachers, care workers, social workers. Is the age of consent to sexual activity the same? There are special protections for children up to the age of 18. So even though children 16 and over are allowed to consent to sexual activity, they are still considered a vulnerable group when it comes to child sexual abuse, when the other party is in a position of trust, and that's due to that possible power imbalance. So there is special protection for children up to the age of 18, and that means a school teacher would not legally be allowed to have any sexual activity with a pupil if they were under the age of 18, even if it was consensual. What about familial sexual offences? Sexual activity between close relatives is an offence, and that includes biological and non-biological relationships that arise through fostering, adoption, and through step-parents and step-children. In the next session, we're going to learn about the definition of things like rape, consent, and penetration, and we'll also discuss some interesting questions like, can a woman rape a man in English law? Thank you for listening, and if you found this session helpful, please like and subscribe, and don't forget to check out the other resources on my channel.